Now that then binds the Crown to the contract and binds the Crown to that law because it complies with the Constitution. No law has been done that way since 1973, or very few in the early days, but none definitely since 1980. So no law in this state is valid. They are not actually laws, they are acts. Until they are stamped with a royal identifier and signed off as complying with the Constitution, they are not law.
Okay.
Doesn't matter how many judges sit in court, and getting to judges, they've all got the word quorum in front of their name. Quorum means unelected judge, or a person impersonating a judge who is not a judge.
Impersonating a judge.
So every single so-called judge, including the Chief Justice, are committing fraud. Now, Wayne Martin has not sworn an oath of allegiance to the Crown. So he is not an officer of the Crown. Right. Well, why is he sitting in our Supreme Court claiming to be a Chief Justice? Because in the scheme of things, he's a fraudster.
Right.
He can call it whatever he likes. That is fraud. Fraud on the people. He's claiming to be something that he's not. And is in breach of certain acts, which I'm not going to bring up.
Okay.
But the magistrates, the Magistrate Court Act, requires magistrates to swear an oath of allegiance to the state and its people. Well, sorry, the state is the people. So somewhere down the line, they got mixed up and confused. But that oath is an unlawful oath under the Western Australian Criminal Code, because the only oath you can take in this country is to the Crown of the United Kingdom, according to the 3rd schedule to the Federal Constitution. Now, they unlawfully removed the oath of allegiance to the Crown with the Oaths, Affidavits and Statutory Declarations Act in 2005.
But shouldn't that have had to go to a referendum to change that oath?
It required one, but even with a referendum they couldn't remove it and remain under the Crown. It's an impossibility. What they did is alter the state constitution that no longer met the requirements of the Federal Constitution. It made it repugnant to it. So all the laws made under that Constitution at this time are invalid.
And earlier on you referred to the Governor-General.
Yes.
And you emphasised him. Why did you say that?
Because every reference to the Governor-General says he.
And we've got a she.
We've got a she. They want to change it, fine. I have no problem with them changing it. But it must be by referendum. You can't change one letter or word in the Constitution without a referendum. Look at 128. They want a female, fine. Have a referendum. Till then, we don't have a female Governor-General.
Yes.
It's as simple as that.
Right.
We've got a Constitution for a reason. This is not discrimination. Maybe it was when they put it together, but that was a reference made in the Constitution.
So there's no reason why it couldn't be changed as long as that was the will of the people.
That's correct. Yeah. The same as in 1966. 90% of Australians voted to give Aboriginal people exactly the same rights as us. Well, how come they've got all different departments and everything now, pandering to them, and they're giving them absolutely nothing? The poor buggers are starving to death. Yeah. And you go out to the missions, they get nothing.
Yeah. Yet in the 60s they were reasonably well looked after.
And they should be. The governments need to wake up and start looking after the people.
Right.
All of them.
Quite good point. All of them.
All of them. Yeah. Doesn't matter if they're black, white or brindle. We are all Australians.
We're all Australians, yeah.
And we are living in this country as Australians.
Yes.
Financing everybody as Australians. Why isn't it happening? Because we're being ripped off by donkeys that sit in Parliament and openly admit that they are liars. They don't really have to. We know they're lying. Their lips are moving.
Could you comment, I brought up just before the interview, because I wanted to talk to you about it, was the Civil Procedures Act. Now, that's been...
That was outlawed in 1996 with a cable decision in the High Court, CLR 189 and 1996.
When was it brought in? You know?
I have no idea, but it's the biggest load of rubbish out, because under Chapter 3 of the Constitution, both civil and criminal must follow the same procedures, and they can't deter from it, because all courts in this country must sit under Chapter 3 of the Constitution. You go back to HCA 29 of 2009, for Lane versus Morrison. all courts must sit under Chapter 3 of the Constitution.
So,
Is all encompassing.
So does that mean that in the magistrates' court you should have 3 magistrates hearing it?
No, a magistrate is an adjudicator.
Right.
What should happen in there, and the recent Finks Motorcycle Club case in the High Court pretty well explains the position of a magistrate. They are to adjudicate between the accuser. We'll say the police department accuse you of committing an offence. You go in there. If you agree, the magistrate has a right to sentence you. Mm-hmm. If you don't, the magistrate then cannot deal with that anymore. They do not have the power under the Constitution to sentence you.
If you don't agree.
If you don't agree. It must go to a trial of your peers, 12 people, a jury. Now, the Act of Habeas Corpus, which is law in this country, you can look up Habeas Corpus in Section 33 of the Judiciary Act, or under Chapter 3 of the Constitution, or in several other references in the Constitution. It is an imperial act. It is law in this country. Now, Habeas Corpus says no single judge can sit in judgment of any person. Mm-hmm. No cost order can be issued without a trial by a jury sitting in a judicial function.
Well, that's also in the Bible too.
That's correct.
Yeah. King James.
Yeah. Which is common law in this country.
Yes.
It was put in place by King James in 1614 as the common law of the people, along with all the other imperial acts. They're law in this country under the Imperial Acts Adoption Act, common law.
And Queen Elizabeth reiterated that in her coronation in 1953.
Exactly.
Right. So we've done with the writ, the mandamus. In the preamble, which John Howard attempted to remove from the Constitution, it says that the people are sovereign. Do you remember that section?
Yes, it's on page, from memory, 283, and it's comments on the Constitution by Mr. O'Connor. He says, if it was asked of a politician what's the highest authority in this country, he would say the state constitution that leads near the truth but doesn't reach it. Because the highest authority in this country is the sovereign people.
And some people would say, in criticism of that only applies to the American Constitution.
Depends how drunk you are when you read it.
Right.
If you're sober, you'll understand that we're sovereign.
Yes.
Go back to 1898 Hansard, and go back to Griffiths J and Isaacs, two of the people who put the Constitution together, and they state quite clearly that at Federation, any sovereignty that the government ever had, of the colonies ever had, is totally demolished and resides solely and wholly in the people under the Constitution. It couldn't be any clearer than that.
That's very clear. Yeah,
now, if you go into the Cable decision again in 1996, it recognised the importance of Hansard of 1898 in deciphering the meaning of sections of the Constitution.
Right.
And it should be read, and it's interesting to read it.
So what is this Cable decision? Because you've mentioned that a few times tonight.
The Cable decision was one of the best decisions in the last few years. I say few because I've clocked up a few.
Yeah.
To come out of the High Court. It is described now as the Cable Principle because it covers so many aspects of clarity in the Constitution. It clarifies that much of it, it's not funny. And if you read the Cable decision, you'll see how much authority it has, because it actually refers to particular sections and what they actually mean.
Right.
The judges who sat on that were really
switched on.
Well, really switched on, yeah, like you wouldn't believe. But we've had the Cable decision, Lane versus Morrison, which I've referred to, the Ford's decision in 2006, and several others that literally are explaining to people their rights under the Constitution. We had some very brilliant judges. Michael Kirby, Murray Gleeson, who was the Chief Justice for quite a few years, Gromau, and all those people. They are very intelligent. We now have, I believe, one of the most intelligent, being Robert French. Or not maybe so much that. He goes to great lengths to intricately